Okay, you're requesting the permission to practice pursuant to Michigan Code Rule 8.120 under the supervision of Ms. Sullen. Is that correct?
That is correct.
You're doing that on behalf of yourself and your partner?
Also correct.
Okay. Have you guys been before me before, or you guys new?
Last week we were here.
Oh, must have been memorable. All right. Permission to practice is granted. Go ahead.
Okay, thank you. So, as you probably know, since our last hearing, we have filed our answer with counterclaims and limited defenses. So, we are requesting limited discovery as it relates to the contract to buy, which includes communication between the parties. And
Counsel, again, can you just back up from your whatever device you're on?
sure, I
Because
think
you really are coming through to me very, very like you're right on the microphone.
okay. I'll use my inside voice.
All right. Go ahead. Give it another shot.
So, since our last hearing, we have filed our answer with counterclaims and limited defenses, and are requesting limited discovery as it relates to the contract to buy. It's going to take us some time to get records of the Sarah conduct as well as the alleged DTE payment from DTE to Johnson to make required kitchen repairs. And we are happy to work this out, but as of yet have not come to a fair agreement.
Okay. If I may, Your Honor, this is, I believe, the fourth hearing on this case. This is a termination case. With all respect to counsel, and we had a phone conference yesterday. I believe all of their affirmative defenses and et cetera filed in their answer are as though this is a rent case. It's not. It's a termination case. Your Honor, at the last hearing, gave them until yesterday to file an answer. Your Honor did not give them leave to file a counter complaint, which they technically haven't, but this is titled including counterclaims, which counsel asks to be heard, and that's what he's asking for discovery for. So my client's position is that he would object to any further. We consented to an extended initial adjournment. We consented to the second adjournment. At that point, Your Honor said once more. Your Honor gave them one more. We objected then to their third adjournment to today's date. And Your Honor gave them until yesterday to file an answer, again, not a counter claim or counter complaint or whatever we want to call that. It's a simple termination, Your Honor. The defendant has not made any payments in a year. The issue, really, I think what Your Honor kind of drilled down to at the last hearing was she's saying that there's I believe it's a lease with an option to buy. My client is saying no such written document exists. The clinic has represented her at least since August. I wasn't involved back then. I'm not sure the exact dates. I said, fine, guys, if there's a written agreement, by all means, please show it to me. My client's telling me there isn't one. So that hasn't been produced. And my client just wants to move forward with, it's a straightforward termination of tenancy.
Well, with reference to the first thing you said, if they wish to file their counterclaims, I mean, I'm not speaking as to the merits. I mean, I think they're entitled to do so. So, the real question, though, from the court standpoint, and counsel should be aware, I had these parties before me, I don't know how many times, trying this same thing over and over. And somebody can't seem to get it right, but that's okay. That's why I know that there is an issue regarding, or at some point there was an issue, at least alleged, regarding the sale of the premises. Is there a document that evidences that?
Plaintiff says no, Your Honor.
And from our side, if I may, we are just saying that we need more time to investigate. And probably, as you remember, this alleged contract, the sale has come up in court before, which Mr. Johnson did admit that it does exist, or at least they discussed it.
Well, what I can say is respectfully to address the court's comments. My understanding is this is the first time that this has been brought as a termination as opposed to a failure to pay rent. Again,
This is the first termination case?
That's my understanding, Your Honor. Again, I
Okay,
was not
I got
involved.
you.
Also, and you know, hey, I could be sitting here saying this is the first time I'm involved, so of course it's the first time it's going to go right. But be that as it may,
Yeah.
this has been going on for this amount of time. My client said that there was a verbal agreement, that there was conversation about that with Miss Walker's husband, who unfortunately passed away about a year ago. So if there was an agreement, at the very least, circumstances has changed. Also, for the past year, it's not like Miss Walker has gone to this or any other court to try and enforce this agreement. If the idea is that my client is not not in compliance with the agreement, my client said he says there's no written agreement, Your Honor. I have not seen one. Counsel hasn't given me one. Again, they've had at least until August. They could have sent it to me when I sent the notice. They could have sent it to me at the first hearing, second hearing, third hearing, etc. I've been begging for it. I got nothing. In order to have discovery and move forward and for this court to entertain that, I know this court is well aware there has to be some sort of offer of proof. And quite frankly, there just isn't one.
Stepping away from that for a minute. So I'm looking at this answer. Is it the claim of the defendant that you paid rent or whatever would be what might constitute rent, that she's paid in full?
No, not that she is paid in full, Your Honor, but I think there is some discrepancy if, like, as to what that balance would even be, especially since I believe a year or so ago, it came up that the payments were being made when the other side was still receiving payments from the SARA program. So, you know, we from our end, we also
the
don't have
SARA
anything.
program, the SARA program would have just paid in 2001 and part of 2022 before the SARA program disappeared.
Mm-hmm.
So I'm saying from the time of that payment, and that would have usually been just paying back rent plus maybe some future rent up to a certain point, usually not more than 3 months from the time of that payment. So my question is, and you know, I just skip all of 2022 and just say for 2023. Is there a claim that all the rent's been paid for 2023 or what might constitute rent?
No, that is not what we're claiming, but it's also unclear based on the status of the lease, like what the rent would even be, especially since the amount that Ms. Walker was paying was the amount that corresponds to the alleged like rent to buy agreement. So we don't even know, like that's why we're asking for limited discovery, just to get more information as to like what the parties actually.
Well, what's your client claiming the rent is? I mean, I don't know. Why would I be giving discovery regarding rent if your client can't tell me what the rent is? That was a question.
Your Honor, I just want to briefly state that the rent, we are not claiming that she has paid the rent in full, but our further claim involving the conditions, we believe is sufficient for an abatement of what has not been paid.
Your Honor, I saw I believe it was the hearing before last, so I am not trying to make that mistake, but I do believe I have to point out at this point, rent is not an issue in this case. This is a termination.
Sir, I get what the case is.
I understand.
Somehow, quite frankly, your client has messed this up, and I'm surprised he didn't tell you about the previous hearings. I think he's been here 3 or 4 times before. Many times I've had to throw it out. So don't try to tell me what the case is about. I've been doing this a minute. I'm asking these questions for a very specific purpose. Counsel, for the defendant, tell me what makes you believe that the court granting you discovery in this case is somehow going to uncover some option to purchase.
Your Honor, our client has specifically stated that there is a document regarding the option to purchase. I believe that if we conducted a discovery regarding...
But where is that document?
I believe if we recover or we believe the plaintiff has it, and if we could
you think the plaintiff has it? They just told me they don't have it.
We believe that if we could engage in a form of discovery of the communications between the plaintiff and the defendant, we may be able to find it.
Respectfully, Your Honor, my client will testify right now.
Counsel, I don't mind granting discovery where I can see that it's going to lead to some practical result. I mean, is it your allegation that for whatever reason that the plaintiff is hiding this document? Because if that's well, before you answer that, if that's the allegation you're making, I need you two to understand that's a serious allegation.
We believe he needs to be ordered to produce.
Pardon?
We're arguing that he needs to be ordered to produce said document, or I mean, yeah.
Why? How am I going to order a document that they're claiming doesn't exist? I don't. Well, hold on, counsel. I don't mind giving you that order.
Understood.
But then if you're asking for something that's frivolous or does not exist, then I'm going to let you know. I'm going to be sanctioning.
Understood.
Because I've got to have some good faith belief that that exists prior to me ordering somebody to do something.
No, I understand.
And I haven't heard it yet.
Understood. And I think I'm going off of a lot of the facts from that February 2023 case, where it was admitted that the defendant and the plaintiff had not seen one another in person, but there was, like, on the record, an admission by Mr. Johnson that the agreement did exist. So we think there has to be some sort of written.
You have that? You have that on record?
We do. There is a video of the trial, sir.
Of a written agreement.
Yeah. We do not have a, like, that's the point of the limited discovery, is that if the two parties were not communicating with each other in person, there has to be some sort of written communication about this alleged contract to buy.
Or someone's mistaken or confused and there is no writing, but they thought there was. That's another perfectly rational explanation for that.
Yes, I understand, but isn't that the point of limited discovery, so we can get to the bottom of the question?
We can have this esoteric conversation. I don't need to be a part of it. Here's what I'm going to do, folks. Have you provided to plaintiff's counsel at all that copy or that portion of either the hearing or the transcript that indicates that his client admitted there was some agreement?
No, Your Honor. We can provide it.
But you haven't.
We have not.
And if you haven't provided it, why not? He's claiming that it doesn't exist. You're saying, well, your client admitted it. Why wouldn't you just show him that here's what your client said, and can we have a copy? I don't understand why I need to be involved in this.
With
We
all
have
due
to-
respect, Your Honor, I very specifically requested that yesterday afternoon.
I
in the
don't
conference.
care.
I
I don't care.
I would like to put that on the record.
I'm not asking you.
We have discussed it with opposing counsel. It is available on YouTube. We asked him if he had seen it. He told us he had not.
Give me final settlement conference day. Just give me a Tuesday.
There's.
And we will send it today.
6 or February 13th.
February what?
6 or the 13th.
All right, folks, here's what I'm going to do. You get that information to them, tell them this is where we're getting it from, what necessitates our request. I mean, it's really simple, folks. This doesn't have to be a hide the ball game. So I'm setting this for final settlement conference. Parties need to appear in person February 13th, 2024, 9 a.m. And I'm just going to walk it through with you guys in person. I want the parties there. All parties must be present with the authority to settle the case.
I'm sorry, Your Honor. I didn't hear the time.
9 a.m. sharp.
Thank you, Your
In
Honor.
person.
May I respectfully request, Your Honor, that the defendant have to post a bond or pay rent into escrow, as this will be the 5th hearing on this.
I get the number of hearings, counsel. I also sat through 10 hearings with your client who didn't know what he was doing. So the fact that I'm at 5 now doesn't matter to me. I will take your request for escrow, which would become effective February 1st. I will deal with that on the 13th. Not dealing with it today. I'm done. We'll see you on the 13th.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
In this hearing, the court addressed a long-running termination of tenancy case that has appeared before the same judge multiple times, involving a tenant who has not paid rent for an extended period, and who now asserts defenses and counterclaims centered on an alleged option-to-purchase agreement. At the outset, the court granted limited permission for supervised practice to clinic counsel, who explained that since the last hearing the defendant had filed an answer containing counterclaims and limited defenses, and was now requesting limited discovery, specifically seeking communications and records related to a purported contract to buy the property, as well as documentation tied to alleged utility payments and repair obligations. Defense counsel argued that more time was needed to investigate these matters and suggested that past discussions between the parties indicated that some form of purchase agreement existed, even if it had not yet been produced. The plaintiffs' counsel strongly objected, emphasizing that this was a straightforward termination case, not a non-payment or contract dispute, and that the court had already granted multiple adjournments. Counsel stressed that no written lease-to-own or option-to-purchase document existed, that the defendant had not paid rent for approximately a year, and that despite repeated opportunities, the defense had never produced any written proof of such an agreement. The plaintiff argued that permitting discovery without any offer of proof would only further delay resolution and unfairly prejudice the landlord. The court, clearly frustrated by the procedural history, noted that it had presided over this matter several times already and that the same issues continued to resurface without concrete evidence. While acknowledging that the defendant was technically permitted to file counterclaims, the judge focused on the core question of whether any credible basis existed to justify discovery, particularly where the defendant could not identify the rent amount owed, could not claim rent had been paid in full, and could not produce the alleged agreement. The court pressed defense counsel to explain how discovery would realistically uncover an option-to-purchase document when the plaintiff denied its existence and no copy had ever been shown, warning that ordering production of a document alleged to exist without good faith proof could expose counsel to sanctions. Defense counsel responded that prior court proceedings, including a February 2023 hearing, contained statements suggesting the existence of an agreement, possibly reflected in communications rather than a formal document, and argued that discovery was necessary to resolve whether such writings existed or whether there had simply been confusion. The judge rejected the idea of engaging in speculative or esoteric discovery and questioned why the defense had not already provided the plaintiff with the specific hearing footage or transcript allegedly containing the admission, noting that this should have been shared directly rather than requiring court intervention. Ultimately, the court declined to grant discovery at this stage, instead directing the defense to immediately provide the plaintiff with the referenced hearing materials to clarify the basis of the claim. The judge then set the matter for an in-person final settlement conference, requiring all parties with full authority to settle to appear on February 13, 2024, at 9 a.m., stating that the court would personally walk through the issues and attempt to resolve the case efficiently. A request by the plaintiff to require bond or escrow payments was acknowledged but deferred, with the court indicating that any such request would be addressed at the next hearing rather than prolonging the current one. The proceeding concluded with the court emphasizing that further delay, lack of preparation, or failure to present concrete evidence would not be tolerated, and that the next appearance would be decisive in moving the case forward. For more information, like and subscribe to my channel.